slovenly and utterly careless and unreliable. There was, for instance, no explanation why the index number entries in the register started from number 38 and how the missing ones were counted. The register itself was shown to be replete with unfilled student information gaps, which the witness explained related to students who had not collected their KCSE certificates. The witness was numerously referred to incomprehensible entries in the respective columns, such as one where the entry Rwandese was made in the column for date of leaving school, while in another one the entry India was made in the column for school leaving certificate number. These are incomprehensible entries. Faced with these instances, the witness was made to admit that there were mistakes in the register, rendering it an unreliable reference point for student information. The evidence of this witness and the state of Exhibit 25 brings serious question its reliability as an exhibit in this case. Then there is finally the question of the opinion of the document examiner in which was submitted to be unreliable. In relation to the opinion of the document examiner, defense submitted to the effect that the opinion relating to Exhibit 10, Exhibit 10 is a school leaving certificate, is prejudicial to the accused because it is based on a photocopy of the document, and further does not explain how the long duration between 06 and 2015 and the condition of the witness may have affected the way his signature has changed over time, and that he also did not provide a calibration certificate. In response, it was submitted on behalf of the state that the omission of such details did not alter the evidentiary value of the document presented and the document examiner's report. No sufficient justification exists for the use of a photocopy of Exhibit 10 when, as has already been seen, it was clear that from the evidence that it was not the original document submitted by the accused to capture. State relied on Republic versus Thomas Kipruto Maritime of 2019 to reiterate a finding that the use of a photocopy for document examination in the case was a minor irregularity because it had been shown the document came from a genuine source. Circumstances in the cited decision are however distinguishable, in my view, from the ones in this trial, where there are genuine doubts about the security of custody of the question document. It may be okay if it's a photocopy, which chain of custody is clearly established. But where there is a problem, then there is a problem. The document examiner's opinion is also attacked on the ground that based on deficiencies in his report, it is not informed from a full consideration of all the relevant matters. One of them being the likelihood that a signature may be affected by age and condition at time of signing, and also the use of a control sample that was not from the regular work of PW12 as a principal at Highway Secondary School. It is demonstrated that the samples were taken on 18th November 2016. The question signature was for the year 2006, and the non-sample used was not obtained from a school document. While it may, in the real sense, not have occasioned any irregularity in relation to the findings, it is not very clear why the sample signature used was not obtained from the documents the PW12 as principal regularly signed during his tenure as principal of Highway Secondary School. The admitted omission by the document examiner to demonstrate that his opinion took into account the effect of age of the signature and examination is, in my view, a grave and prejudicial omission, as he admitted that such factors have a bearing on the opinion that may be ultimately formed. In the circumstances shown here above, it is difficult to agree with the state's admission that evidentiary value of the document examiner's report is intact. From the foregoing discussion and collectivity of the findings, it is clear that the evidence adduced herein against the accused lacked the necessary sufficiency, credibility, and coherence, and the procedures for obtaining some of which did not accord with the requirements of law. I find that the general defense submission in this regard is merited and must be upheld. Determination. I now address the individual counts generally and in view of the foregoing. Counts 1, 2, 3, and 4. These charges relate to forgery and uttering of M51 and M520. 074 and King Diploma Certificate number 36262 are not produced on record and are not proved to be forgeries in that case. Both counsel for the state and the accused have cited the seminal decision in Caroline Wanjiku Ngugi versus Republic 2015, in which the ingredients that are necessary to be proved in a charge of forgery were discussed, citing the Indian case of Sukati Choduri versus State of Orissa in India. In his decision, Justice Mativo Chivo, in one of the quotations citing the ingredients, rendered himself as follows. Referring to the another Nigerian case of Alaki versus the state. The ingredients of forgery, for the offense of forgery, are as follows. Number one, that there is a document or writing. That is the first thing that must be forged. Number two, that the document or writing is forged. Number three, that the forgery is by the accused person. Number four, that the accused person knows that the document or writing is false. Number five, that he intends the false document should be acted upon to the prejudice of the victim in the belief that it is genuine. Those are the ingredients that must be proved in a charge of forgery. There was also reference to the case of Patrick Miguna Ritu versus Public 2018, cited on behalf of the state, in which the following passage appears. And I quote it. A document that is false must tell a lie about itself and not about the matter. We think the position is better put by stating that the false document is forged if it is made or used, if it is made to be used as genuine. End of quote. Having regard to the two decisions, it is plain that the proof of a charge of forgery and by extension, the kindred offense of uttering must entail the proof of a false written document as a public offense. Further, the fact of being false must be established purely by considering the document itself and not from extrinsic evidence. It is the document itself that say I'm lying. Exhibit 10, which is the subject of considerable discussion herein above, was produced in support of the charge of forgery in count 5 and the charge of uttering in count 6. It has been ascertained on available evidence that the person named in the document has not been correlated to the names of the accused in the charge. So the document and the identity are various. There is no evidence on record to show that the accused, assuming he was properly correlated to the document, met Exhibit 10 in terms of the highlighted ingredients for the offense of forgery. The state's attempt to show that he was the originator of the Exhibit 10 is not properly established on the evidence, because I've already seen that conclusion is tenuous from the evidence itself, starting with the fact that the names on the document do not properly match his. So the first thing is to correlate him with it and then say it originated from him. Exhibit 10 has no indication that it was the same document submitted by the accused to IEBC Kapseret Constituency Office and received by PW1. It is also now clear that there was an original of it sent to IEBC headquarters in Nairobi by PW1 and retained in his file there. The accused file kept at the Kapseret IEBC office was not availed intact with the documents containing it. Neither had the Nairobi file housing the originals, as claimed by PW1, been availed as well. In relation to this charge and generally, no basis is laid for use of secondary evidence. Finally, the document examiner's opinion in relation to the charge of forgery is not well founded, as already found. Without further ado, I find that the charge of alleged forgery of Exhibit 10 in count 5 against the accused is not properly established. The same is similarly here by this case. Absent any evidence showing that PW1 specifically received Exhibit 10 from the accused, and absent any evidence that the person named as Sudi Mp Oscar is also the accused, the kindred charge of uttering in Exhibit 10 to PW1 as alleged in count 6 is also without foundation and is equally dismissed. In relation to count 7, 8, and 9, count 7 is founded on information allegedly provided by the accused PW1 under Part 5 of the self-declaration form, which is Exhibit 8. The perusal of the hand-filled form does not show that the accused wrote under Part 5 of the form the details about a KCC certificate as alleged in the particulars to this charge. There is no mention of a KCC certificate in the declaration, which this charge is based on. There is no writing or express mention of a KCC certificate, and there is only what looks like a mark below the text secondary in this regard. Count 7 is clearly not supported by the documentary evidence before the court, namely Exhibit 8. Count 8 relates to information allegedly provided by the accused to the investigator during their meeting at Heron Portico Hotel. I have since found that this information was regularly obtained and the same was excluded as evidence. There is therefore no evidence to support the charge in count 8. In addition, Section 70 of the Evidence Act provides as follows, and I quote, If a document is alleged to be signed or to have been written wholly or in part by any person, the signature or the handwriting of so much of the document as is alleged to be in that person's handwriting must be proved to be his handwriting. So the declaration had to have been proved in the handwriting of the accused. Exhibit 8 is a standard form containing hand-fill information attributed to the accused. There is no evidence before the court to link the handwritten entries on part 5 of the document to the accused to satisfy the requirements of this section. Finally, count 7, 8, and 9 are built on the premise that MFI 9 and 20 have been proven to be forgeries and therefore false documents, which is not done. By this fact and for all the preceding reasons, the three charges fail and are hereby dismissed. In conclusion, in view of the foregoing, I find in accordance with the principles applicable that the state has failed to make a prima facie case sufficient to warrant the calling of the accused to make a defense in all the respective charges preferred against him. The orders that fit this trial are that upon conclusion, I agree with defense submission that an order of acquittal should issue, which is hereby issued under Section 2 CPC in relation to each charge preferred against the accused here. Right to appeal 14 days.
Justice normally grinds slowly. Yes. It has taken long, and when it grinds and comes to a halt, yes, it grinds harshly. And harshly, my lord, it can be both positive and negative. Yes. You know, in these circumstances, we really appreciate that it has been positive on our side. Yes. Thank you very much.
Investigations that have been involved right from the beginning to the end of it. Yes. And I've learned so much through your guidance and also the State Council as well as our Defense Council. Most emphasis, I would like to thank my lead counsel, Mr. Ruto, together with the young men who were with us, particularly Mr. Tunen, for having exhibited very, very serious interrogation skills, of which I would believe that I would rather say it off record that he deserves to do a master's degree in case he has not done any. Yes. And I've also learned a new set of jurisprudence. I'm actually, I teach criminal law to the highest level of my life, and the experiences I've had from a Kenyan court have added value to what I thought I knew that I did not know. And I'm forever indebted to criminal justice in this country for having been patient, Council, Johnny Cochran. And I feel that our country is going to the... Sasa tafadhali mtupatie nafasi. Wapi Ruto?
Has been very patient, having the court, and to confirm that the allegations were just mere allegations. And our client, we do confirm, is qualified, doesn't have fake certificates as alluded, and he has been set free by the court. That's all. Thank you.
Yeah, ladies and gentlemen of the press, I don't have much to say. A lot has been said today. One of the things I've noticed in this country since I came back is a lot of people are too much into rumor mongering and hearsay. They produce something very small and they put somebody's name into a lot of mud. Today the courts have proven, and this is the first time I've been involved in litigation right from the beginning to the end. I have to thank the senior counsel here because he's been our head. I'm not saying senior counsel per se. He's been head of this litigation, and together with our team, with Mr. Tunen, where is the others? Just say your name so that you... Wamalwa here. Simiu. Where is the other gentleman? Njiru. Any other person on the team? That these young men you have seen today have demonstrated. They have demonstrated that the kind of education we have, or legal education we have in this country is real. I sat behind and I heard these young men argue. And I was like, wow, was I in a UN court, US court, UK court? I found that the judicial system in this country works because it has worked for us today. Sudi has been called so many names. If you don't have a background and you have a problem, you'll be named so many things. Today, God has proven to us that what this gentleman has gone through for the last 8 years has been in vain. You concoct a case, you put somebody on trial, you waste that person's time for all that time, you interfere with his family, you interfere with his constituents, and I'm sure we shall be going to Kapsaret very soon to tell the people of Kapsaret that Sudi is Sudi yet, and Sudi again, and again Sudi. Thank you very much.
The advocates that were involved in this matter. We would like to really thank the judicial process, beginning with the court, for the lengthy, well-reasoned reason to work for the people of Kapsaret and for the people of Kenya. And we really thank